All right. Welcome to our last section or our last week of the first section of the class on copyright. We will be transitioning to licensing, which is going to end up taking the majority of our class time moving forward. But once again, it's really important to have a strong foundation in copyright, with particular attention to the idea of duration, in order to be able to deal with licensing. And the reason that is licensing is the most visible, and I guess the most like the first thing you think about when you think of a music publisher. It's the way they make money for songwriters and copyright holders. But it doesn't really get to the issue of, what is going on with a music publisher. It's just part of what they do. And so to really understand what's going on with a music publisher, I find it's really useful, not only to start with copyright, but to focus on duration. And then we start to see the position of the music publisher in its broader context, how they operate, why they do what they do, and how they're regulated, in particular by the federal legislation regarding their ability to hold on to a songwriter's copyright indefinitely. And so that's really what we want to talk about today. Now, this week is primarily about infringement, but I do want to wrap up from last week. So I want to talk about, this relationship between copyright duration and publishing as a conclusion from last week's work. And then I want to make sure that we're all good on, go over a couple of those problems from the assignment sheet, the duration worksheet. So first things first here about the relationship between copyright duration and publishing. So we started with copyright, focused on duration. Now we're going to look at, move into this idea of copyright infringement, which is, the unlicensed use of copyright, a work that's still protected, but someone uses it without permission. And that permission is typically granted by a publisher who is acting on behalf of the copyright owner or the songwriter in the case of music business operations. And so when you think of duration, it protects the time of money making, right? And so the time of money making, or the act of money making, is referred to as exploitation. So we have these forms of personal property, or intellectual property. And the government says for this amount of time, based on when it was made, as we just saw with the duration worksheet, for this amount of time, now it's life of the author plus 70 years. You, meaning the owner, or anybody the owner transfers that copyright to, right? That's called an assign or a transferee. Have the exclusive right to capitalize on that, right? To make money. And that, of course, is done through licensing. And so who's best to to exploit intellectual property in the creative industries? Well, on the music side, that person or that entity, usually a company, is referred to as a publisher, a music publisher. So why are they better at doing that than the songwriter who gets the copyright themselves? The reason is because that's their gig, right? It's their job to know what music users, film producers, TV shows, record companies, video game designers, you name it, sheet music publishers. Those are all music users, and so who those people are, and if they have projects going on, and if they're in search of a certain kind of music, and who within the company is in charge of acquiring or supervising for a film, a music supervisor. So they have, the magic sort of black Rolodexes, in the old school way of discussing this stuff. They've got the contact list. They're the center of the professional network. So they're supposed to be ultra LinkedIn, and, connected with a wide variety of the music business. And so they're the perfect entity to do this matchmaking. So this film, project is underway, and they're doing something kind of retro from the 60s, based out of Detroit. So boom, let's approach, the holders of Motown catalog, for example, Berry Gordy and others, being the best, representation, of that time period and that place and time. And so what they then will do is, identify who has who the songwriter is and who their publisher is. And that is a ownership group, right? So the songwriter and the publisher. Oops, look at this. That's going to come up again, I'm sure. Sorry about that. That's an ownership group. So the songwriter has the copyright by default because they're the creator. Statute of Anne says you created, it's yours. And but they are not the best person to put it out there and get it to make money. So here comes the publisher saying, that's a valuable piece of work there. Let's get the most out of it that we can. And I'm going to offer you a songwriter deal and a music publishing agreement, or a songwriter publisher contract. And what that does essentially is to transfer the ownership of that copyright away from the songwriter to the publisher. And so now we're in a even more complex situation where the copyright has been reassigned away, to the publisher, who, because they are the owner for the term of that contract, right? And sometimes the contract can be written for the entire life of the copyright, and that's what is a potentially dangerous situation, because the publisher can then say, I'm not really as motivated as I thought I was. I'm just going to sit on this thing, and they can seriously do damage to the potential value of that copyright by sitting on it and doing nothing. But most of the time, a reputable publisher will say, okay, now that I'm the owner, I'm completely motivated to get this thing out there. And so they, try to place it, or, plug it. Song plugging is the industry terminology there. And whatever the standard agreement is, whatever I make, I'm the publisher now, whatever money I make by placing it in film, getting a cover song, putting it in a video game, getting, international, use of it, whatever it may be, that's going to be split 50-50. And so that's the typical deal. However, because the songwriter transfers copyright, and it can be forever if they don't read the fine print of the contract. How long am I transferring the copyright? Now I'm the songwriter. How long am I transferring the copyright to the publisher? Well, if it's forever and they do nothing, now we have this idea of copyright recapture. And so if you saw Coco and Dante's presentation, that was part of what they were looking at, was, how long do songwriter agreements last for? So copyright itself has a duration, but you also have within that, how long does this agreement between the songwriter and the publisher last? And if you have a poisonous situation where the publisher's like, I've got you to sign this document, but now, I'm actually not a very good publisher, not very motivated to do anything, then federal law steps in and says, songwriter, you have the right to recapture that song in between 35 and 40 years after the transfer, as long as the year before that window opens up, you, as the songwriter, notify your intent to the publisher to recapture. And so terminating that transfer, and then the copyright then comes back to the original songwriter. So this is, two different levels of duration. So we got the length of the copyright, but now we have the length of the agreement between the songwriter and the publisher, and the copyright is mobile, right? It's moving between those two parties. And so this is an important wrinkle. I think it's probably the easiest way to see what's really a complex situation is through this window of duration. And so that's why I wanted to, to kind of focus on duration. So before we move on to infringement, I did want to go over a couple of the duration assignment itself. So what I found was, out of 5 points, if you got 4 or 5 correct, that's what I would consider to be good comprehension. And the class, about 70, just over 70% of the class got 4 or 5, which means that, I have to make a decision there, because that's a significant portion of the class that 30% of the class not having almost 30% not having, good comprehension of this. What I decided to do was look at where the problems were in that assignment, and really it was the work for hire, the last 3 problems that before the true false, because work for hire has a different timeline. So you'll remember, you've got these different categories of these different math equations for if your work is published, if it's unpublished, if it's a work for hire, or maybe it's an international work. And so as your teacher, we could very easily spend a lot of time on this. I wanted to put in work for hire so you could see, because there are, Circle P or audio recordings that are owned by record companies primarily, or, an independent producer, if he or she goes through all the steps to produce and to create an audio file, that's original. That's their intellectual property. However, audio recordings are calculated on, more times than not, those are calculated on that 95 years from publication or 120 years from creation, whichever one comes first. I think in my last video I said you calculate on whichever comes last, or whichever lasts longer. So that's actually probably, that was a typo on my part, and that may have contributed, but to the problem with these work for hire problems. So what I've decided to do is I will not test you guys on the work for hire problem. So those last 3 on your worksheet, before the true false problem. So it's 7, 8, and 9. Those are all work for hire problems. So don't worry about those. I'm giving you those worksheets as a study guide, and we'll talk about the upcoming test for section 1 of the class in the next presentation here. And so to get to a little bit of review here, let me select a new file. There we go. Oh, I covered up my whole head. I bet you guys are pretty thrilled about that. So tired of looking at Dr. Linden's crazy head. All right. So let's take number 1 and 2. So we had a work that was first published, January, so 01/01 of 1963. And it was not a renewed work. And so when does it expire? Right, that's the question. So we got to calculate the duration of this copyright. So you'll notice that it's 1963, and so you still have to worry about, renewal was not automatic at that point in time. And coming out of 1909, the law said that you could have 28 years plus another 28 years. So you got 56 years total if renewed. However, this was not a renewed work. And so we need to take 1963 plus the 28 years that you get, because it's not a renewed work and it is a pre-64 work. And then that's going to give us 1991. And so that would be the expiration year. And of course, you remember that all expirations go to the last calendar date. So the appropriate answer for number 1 should be 12/31 of 1991. Okay, so the second one is, well, what do you do with this same problem if it is renewed? Okay, so what happened you know, of course, the 1909 law, and you'll remember, let me get my worksheet out here. This is why I had you guys do, you know, I didn't grade this part, but up here, you know, this is how duration changed at these different dates, right? So we're interested with 1909 being 28 plus 28. But then what happened in 76 and in 98, the total of that is that if it made it to 1978, it's still protected, then it automatically went to 95 years. And so that's what happens here. Okay, so it's a 1963, so we still have to worry about the renewal date. And so this one did not get the full 95 because it was not automatically renewed. Okay, so if works were renewed, and that means that they're still being exploited, right? They're still making money. And with the renewal, it gets them past 1977, so they're still making money in 78. Then you've got a situation where it's 1963, and then the law ended up adding 39 years to 56, which gives you 95 years, and you get 2058. So January, 2058. So not January, but December 31st, 2058. Okay, let's do another one. Number 5. Okay. 1923. So it was Independence Day, July 4th, 1923. Okay, here we have a work that is also pre-1964. And it is going to expire at the end of its renewal term. So we take the 56 years, which gets it past 1977. So 28 plus 28 is 56. That's going to get it past 1977 to 1979, which means that it will then get, because it was renewed, it gets the full term, which would be 95 years. 1923 plus 95. It's an expired work, but it did make it all the way out till 2018. And so the answer is 12/31/2018. Okay, so for these problems, make sure that your study guide, and this is your duration worksheet here, is filled out, because this is what you're going to need to remember. Section 2 is required to be able to solve these problems here in Section 3. Okay, we haven't done Section 4 yet, so people who sent me in this pipeline thing filled out, we're just not there yet. That will be upcoming. Okay, so make sure you read the directions. Too many people, unfortunately, sent me like this entire thing filled out, and my directions said, just give me Section 3. So these are the duration exercises. So you have to have Section 2 done. Okay, so the two main groups created by the 1976 law were everything created before 1978 and then everything 78 or after. And we know 78 or after were life plus 70. Renewal was abolished, right? No need for renewal anymore. So it's basically life plus 70, or if it's a work for hire, 95 years from publication or 120 years from creation. It's actually backwards. Publication, creation, whichever one comes first, not whichever one lasts longer. We're not worried about those. So this whole category, if it's a work that's after 1978, that's actually very easy to figure out. And so all of these problems in number 3 here are going to be in this more difficult time period, which is everything between 1923 and 1978, because and if it's before 1923, it's automatically public domain. It's expired. But if it is 23 after, now you have to figure it out, right? Between 23 and through 77. And so in order to figure out this difficult group or more complex group between 23 and 77, I give you, and I covered all of this in the first duration presentation that I did. Now this is why you have these 3 subgroups. And so 64 through 77 is automatically 95 years. 50 through 63 is 28 years if not renewed, and then 95 years if it's still renewed. And then if it's 1923 to 1950, you've got this third sort of category of work there. All right, so make sure you have that and you understand. As long as you have this, you can figure out any of these problems, but you've got to understand, section 2B of the worksheet in order to figure out these problems. Okay, so spent a lot of time there, but it's important because, like I said, the issue of it's going to be you'll be tested on it. There'll be a few of those duration problems on there, and so I want you to be ready for that and understand how they work. So that's it's worth the time. It's not, the test is not going to have a lot of those on there, but there will be some. It'll be an equal representation of the stuff that we've covered. So I'll give you a study sheet and everything. Don't worry about that. We'll get to that in the next presentation. So now I need to turn to copyright infringement. Oh my gosh. And this idea of bringing a case. I don't think I'm gonna. All right. So anyway, so what we're going to go over here is, how do you make a case that, or how, if and when copyright infringement takes place, which is using somebody's work, intellectual property illegally, then what do you do about it, right? How does it come into a court of law? And so a lot of it has to do with making the case and bringing the case. Is there a case? Is it worth it? These are all important questions, obviously. So we'll look at who can bring the case. What's the time frame surrounding the case, and how do you bring the case? How much does it cost? And then types of infringement, types of infringers, and how you actually prove a case. So I'll try to not spend too much time on all of this, but we do need to know what it is. Okay, so who can actually sue here? So legal owners and their beneficiaries, right? So who is the beneficiary of a legal owner? Well, that's, the right of succession indicates that your spouse is first, your children are second, your siblings, and so it goes down the list of how property goes to beneficiaries, with a will, when somebody passes away. So legal owners and their beneficiaries can obviously bring a case. And so who are the typical owners of copyright? Well, for our interest, we've got Circle C versus Circle P. Circle C is going to be usually songwriters and or publishers. If you have a songwriter that is signed with a publisher, remember that copyright is transferred to the publisher. So oftentimes for more famous, songs or things like that, it's going to be the publisher that's actually bringing the suit. Which is actually probably a good thing. They've got the legal power and this is another reason why it's good to have a publisher. In Circle P, however, publishers are not usually the owner of Circle P. They, will help people who are looking for the Circle P owner, the sound recording owner, kind of put them together. But usually Circle P is owned by whom? Who owns sound recordings? that would of course be a record company. So their job is to take Circle C, stick the song, which is the song as a composition, put it with a great performer in the studio, put an engineer in there, record it, and now boom, that's the recipe for Circle P to pop out, right? Then you've got a record. So they are that would be the most common owner of Circle P there. Okay, so you've got your legal owners and beneficiaries include the copyright owners being the songwriter and or the family associated to that copyright owner if they've passed, or the songwriter. Then you've got publishers and record companies on the corporate side. And now you've got what's referred to as a registered assign. Okay, so a claimant or a transferee would be people to whom the copyright has been transferred, like a music publisher. But also in the case of an exclusive license, if you are giving a advertiser or a movie producer, somebody with deep pockets, the exclusive ability to use that song for a year or two, then oftentimes they will require that the copyright's transferred to them for that time. So now you're seeing, once again, copyright as a mobile piece of property moving between the songwriter to the publisher, now off to a user who has an exclusive license. And so that's to emphasize licensee. So these are the people who are in the sort of list of who can actually sue for copyright infringement. When and where? Okay, so copyright law is bound by the statute. For you Seinfeld fans, the statute of limitations. It's not a statue, as Kramer says, which is 3 years. 3 years from the last known infringement. Problem is that it's intellectual property. It's harder to know that it's being infringed, and so that's part of the dynamic here is recognizing when the infringement actually took place, and then the clock starts running from the last known infringement. 3 years after that, that becomes a technicality. The case would be thrown out because too much time has gone by, right? The statute of limitations has expired. Where do you bring the case? So that's the when part. Where is the federal court system? And so, within the federal court system, the district court or the district level is the lowest, and that's where trials begin. So that's where you would file. It's a federal case. It's a federal law. So you choose a federal court, but it's the district level. So it's federal district court in the district of the infringer. And so it takes a little bit of research to figure out, where when the infringement took place. If it was less than 3 years ago, then you have to figure out where it took place, and then which is the correct federal district court, what district they're in, right? And then now you know kind of the when and the where, which is of course where a lot of fun begins, right? You've got to know the when and the where of anything. Okay, how do you bring a case? Well, you've got to make sure that you've got the facts of the case down, and you've gathered proof, and that proof we'll get into in a little bit, maybe circumstantial, or you may have a smoking gun, right? Direct proof. But then you have to actually do the math, right? So court fees, this is a federal case after all. So to file a federal case, and the lawyer fees that are involved, you're oftentimes talking, well into the six figures. So $250,000 is not out of the question to get this thing off of the ground. And so if you're talking about an infringement that is $75,000 worth, that's what you stand to gain from this. It's not a really great decision to say, okay, I'm going to spend $200,000 in order to win $75,000. So there's some math that goes into this. So the amount of the infringement, right, should of course be bigger than the amount that it costs to actually be awarded whatever the amount of the infringement is. Okay, so the plaintiff is the one we're imagining an infringement case. The plaintiff would be the owner, and the defendant would be someone who's accused of using the owner's property without their permission. So the plaintiff files the case in the court, in the district court. They've retained their lawyer and they pay the fees, and now they're ready to get on the docket, right? So there's an amount of time before that case is ready to go. And then when, the court case starts, it's a civil suit. So it's not like we've got, a grand jury or anything like that. What types of infringement are actually, were in the case are important to address. And so, there are informal designations for Circle P infringement, like, bootlegging, making bootleg recordings would be, people who hide recording devices in their clothing, like alcohol bootleggers, people who were trafficking alcohol during Prohibition would hide it in their bootleg. So that's where that came from. And so that's an unauthorized recording of a concert. Counterfeit, that's where you've got, like, in some, other countries, or maybe even our own country, we've got people, and especially in the 90s and 2000s, that would, get a color printer and duplicate the liner notes and the label and really make it look just like it came out of the store. And that would, of course, be for physical product, right? A CD. So that's a counterfeit, just like a counterfeit dollar bill has all of the appearance, like it's making you think, oh wow, this is the actual item, from the record plant. As opposed to piracy, which does not duplicate the label, just the sound file. And so when we talk about pirated recordings on, YouTube, or in the old days, Napster or Kazaa, they didn't come with, any of the metadata. So you didn't have, like, the album artwork and the liner notes and all the things that a counterfeit would have. So these are informal designations. Those are different types of infringement that are common to sound recordings. But in the court of law, you have to abide to the legal distinction between direct infringement or indirect infringement. And so a direct infringement is when is the most sort of egregious type, where you've got all of the it's a complete duplication. Either you've got the entire song or the entire recording, as opposed to indirect infringement, which would be just a piece of either. So you could take a verse from somebody, or you could do a sample of a bass line from a recording, and that would not be infringing the entirety of the work, but just a part of it. So that's indirect, and it's less, less egregious. Different kinds of infringers. Okay, so this is where it starts to get a little interesting. So you can also have a direct infringer. And then you can have other types of infringers, like a contributory infringer or a vicarious infringer. But the direct infringer is the one who actually does the duplicating. Okay, so they knowingly and willfully violate copyright. So it's the person who presses download on the computer key, or who presses, who upload on the, the Pro Tools synchronization project, where you're bringing, image into, or Creative Suites, bringing image and file together and creating a new sort of form of content that has a, an element in there, in this case, the music, that you're not cleared to actually use. And so that's the direct infringer. They're the one doing that. Or it could be an artist that's performing, in a festival, and the festival didn't acquire the artist is performing a cover song, but the festival organizers did not actually acquire the blanket license from ASCAP or BMI to do this. And so those are the direct infringers. Now the contributory infringer is anyone who actually aids and abets, is how the law, that's lawyer language. So, anybody who materially contributes to the process that the direct infringer, so the material supplies the direct infringer materials they would need to actually do their job. So getting a computer, for example, providing software so that the infringement could happen, but they're not the ones actually doing the infringement themselves. So that's a contributory infringer. Great terms, right? And then finally, the vicarious infringer is anyone, they don't even need to know about it, but they end up benefiting from the process. And so the reason you have these different levels, direct, contributory, and vicarious, is because what happens is the owner may have lost a bunch of money, right, through this infringing, um, behavior or act of infringement. And the direct infringer could be a starving artist and not even know they, were doing anything. And so they usually get hit up first to kind of settle the lawsuit if there is infringement that's actually found. And they may have like $1,000 in the bank, and it's like $200,000 worth of fines to pay, and so they're tapped out immediately. And so what the law does is it has this expanding bullseye. So the direct infringer pays first, then the contributory infringer pays second, and if they still haven't, settled up with all of the money that's due, then the bullseye continues to expand from direct, contributory to vicarious until finally all three of these parties are what's referred to as jointly and severably liable, meaning that they can be held liable or responsible to pay by themselves or as a group or any combination. So that's jointly and severally liable. Some more fancy legal language for you. Okay, so let's take an example. So you've got a vendor in a mall that's selling counterfeit CDs. Okay, main players. Person A made the CDs. Person B sells the CDs. Person C provides the cash register and the credit card machine. And the mall is the corporation, that would be person D, that leases the space to the vendor. Okay, who is your direct infringer? The one that made the CDs. Very good. Who would be a vicarious infringer? Okay, the mall, most likely, that leases the space to the vendor, and possibly even the person who is ringing up the sales. They may be selling without knowledge of the fact. They aren't necessarily providing material support to the infringement action, right, that's going on with the person making the CDs. So we don't have a contributory infringer in this example, because unless person B also provides the duplicating software and hardware to the duplicator themselves, then they would be in the sort of vicarious stage. Okay, let's do another one. Oh my God, now 601 Records is in on this. Call the cops. They're promoting a concert where there are cover songs played, but the venue has no PRO blanket license. I'm blowing the whistle. It's the infringement whistle. I don't actually have a whistle, but that was the best impersonation I could do. And so what kind of infringement, is going on here, right? The infringement itself, so if the entire song is played as opposed to just a verse or two of it, then that would be direct infringement. So let's identify the people. So who is the direct infringer here? We've got a record company. We've got artists playing songs. We've got a venue. Can you match those together? Go ahead and do it in the comment section. I bet you can do it. It's not a difficult one, but it's one that you will most likely see again. This is one of my favorite things to ask on a test. Okay, so those are your types of infringement, and those are your types of infringers. And now, how are you actually going to prove infringement? Okay, now we're moving on to proof. And once again, the word direct is in there. So be aware that you've got direct infringement, a direct infringer, and a direct proof. These, same word, different applications. So try not to get them confused. Okay, if you've got direct proof in any law case, that means you've got irrefutable smoking gun, usually video evidence or a direct admission from the defendant that, yes, I did it, you got me. Okay, that's direct proof. They're admitting guilt. But, this type of thing is usually done under the cloak of darkness, right? So you want to remain not you, but infringers prefer anonymity. And so they're doing this thing sort of secretly in order to make it more difficult to, identify who they are. So it's most common that you don't have direct proof in an infringement case. And so you end up with circumstantial proof. And here, it's the plaintiff's job to reconstruct the circumstance. How did this happen? And so now you've got to bring in witnesses, and you've got this proof that tells a little bit of the story, maybe an email or a cell phone call. And so they're putting all of the story together, and they're selling that story to the judge and or jury in order to, show what they believe happened and to convince them, right? So they're making the case for infringement by virtue of constructing a narrative. And so doing that is relying on circumstantial proof because they don't have the direct proof. Okay, so those are your two ways to prove infringement. A little bit of circumstantial proof. So since this is the most common, I just want to give you a little bit more information there. So if you're making a circumstantial case for infringement, you've got to make two. That case is going to rely on two other proofs. The first is the proof of access. So did the defendant have, what kind of access did they have to the property, right? Song, recording, Circle C, Circle B. Was it strong access? Or maybe they said that they gave a demo record to the artist's manager, and then 6 months later, a verse that was on that record now turns up on on their new CD. Is that strong proof? Actually, that would be considered weak proof because there's no, even if the manager's like, yes, I took, they gave me this, but I never gave it to the artist, that doesn't mean, there's no link there between the plaintiff and finally the artist who is being the alleged direct infringer there. Okay, so strong and weak access, a circumstantial case is going to have a proof of strong access and a proof of strong similarity. So the second thing is that the circumstantial case will rely on is similarity. So how strongly similar, or how similar are the original work that the plaintiff is saying was borrowed, used, or whatever, and the work that was ultimately, came out of, that's being claimed as the infringing work. So those two works are held up next to each other. And if they are obviously, the same or super similar, it's like, yeah, that's clearly the same melody and chord change and beat or whatever, then that's going to be a strong case for similarity. So to make a circumstantial case and to sell it, the judge will have to find that there's strong proof of access, strong similarity between the two. If you don't have that, it becomes a matter of judgment. Maybe you've got weak access but strong similarity, or inverted, or if they're both weak, then usually that plaintiff is not going to win that case because there's just not enough there. Okay, folks, so that's a long presentation, but this is, it's part of the bag here. It's just like we've got these properties, they can be valuable. You've got multiple parties that are interested in them, including the original songwriter. They're represented by a publisher. The publisher can issue various kinds of licenses that have their own term of duration, and if any user is found to be profiting from a work that is not protected either by the license, if they're not licensed, or if the song is still copyright protected and they are not a claimant, right, or a transferee, then they've got no business using that, and that's where these court cases come from. So I hope that this helps you see a little bit better the nature of what we're, like our topic area, what we're dealing with when it comes to the actual, how do you make and bring an infringement case? Who are the parties involved? What kinds of infringers? What kinds of infringement? So that's it for today's presentation. I've got another one coming up, and we'll look forward a little bit in that one as well. Thank you very much. Have a great day.